Thanks so much, Madam Chair. I, I want to begin today by talking about the Constitution, the Utah Constitution, that is. I knew I threw you there. I thought you'd be expecting another 1787 moment. Instead, I'm going to go to 1896. My state's Constitution is actually surprisingly insightful with regard to competition policy. Article 12, Section 20 of the Utah Constitution says, quote, "It is the policy of the state of Utah that a free market system shall govern trade and commerce in this state to promote the dispersion of economic and political power and the general welfare of all the people. Each contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade or commerce is prohibited, except as otherwise provided by statute. It is also prohibited for any person to monopolize, attempt to monopolize, or combine or conspire with any other person or persons to monopolize any part of trade or commerce." This is riveting stuff, but it's actually got some good wisdom in it. You notice how in Utah, we've tied free markets and antitrust enforcement, the prohibition against monopolization and the protection of competition itself, directly with the dispersion of economic and political power. This was prescient. Today, our competition problems in this country have truly become political problems. We see this when trillion and billion-dollar monopolists are eager to impose their ideological censorship called for by their political benefactors. And it's worth remembering that some of my colleagues want to punish big tech not because it engages in too much censorship, but because it doesn't censor speech enough, speech with which they disagree, that is. That isn't a competition concern, it's extortion. But our competition problems go beyond big tech. I'm especially concerned by cases in which free markets and competition are distorted by the government itself, putting its finger on the scale to pick winners and losers in the marketplace, whether through regulation or lax antitrust enforcement or otherwise. Sadly, this too has become increasingly common. For example, many parents at this very moment wish very much that they could send their children back to school. In fact, many children who were suffering from record high rates of anxiety and depression themselves wish that they were back in school. But the federal government and many state governments have starved the education market of competition, instead imposing protectionist policies for public school monopolies. Now, maybe if education itself had more competition, say by ensuring that funds followed students rather than schools and teachers' unions, parents and students would have more options and better education. Speaking of the efforts of the pandemic, the last year has been devastating for many small businesses. This is due in no small part to onerous and prolonged lockdowns that shuttered local brick-and-mortar stores and drove consumers into the arms of big tech monopolists like Amazon. I'm glad that so many of my colleagues across the aisle share this concern, and I wish we had all considered this risk while cheering on some of those same lockdowns. The same thing has happened in healthcare too. Just this past weekend, in the midst of the worst health crisis in a century, Congress forced, through a hyper-partisan expansion of the Affordable Care Act, a law that has distorted competition and has been disastrous for consumer choice in health insurance markets. In the airline industry, repeated government bailouts and protectionist regulations have insulated legacy airlines from market forces and foreign competitors. This, in turn, has allowed them to avoid competing with new rivals, meaning American flyers continue to be subjected to higher prices and lower quality services. Yet another example can be found in occupational licensing, something it will be more important than ever to address as millions of Americans struggle to find new employment. To that end, I'll be reintroducing the Restoring Board Immunity Act this Congress to ensure that state licensing boards are not used as cover for professional cartels that protect market incumbents from competition by discouraging new entry. Earlier this week, I also reintroduced a bill called the One Agency Act. Consolidating our antitrust enforcement at the Department of Justice is essential to improving and strengthening our enforcement efforts and avoiding the inefficiency and bureaucratic infighting of the past. This updated version of the legislation also removes the Federal Communications Commission's ability to undertake duplicative competition reviews of transactions under its regulatory jurisdiction. The FCC's application of the public interest standard has been yet another example of government distorting competition, as it's become a go-to venue for rent-seeking by competitors and special interest groups. The costs imposed by FCC overreach are ultimately passed on to consumers who have no say in the process. And those aren't the only examples of businesses attempting to enlist the government in preventing competition. For example, a number of national media conglomerates are coming to Congress, asking Congress for corporate welfare in the form of antitrust immunity to allow them to stage a group boycott against their advertising partners. Despite failing to update their business model to account for the internet economy, and despite continually publishing biased and fake news that many American consumers simply don't want, these companies believe that they're entitled to engage in federally sanctioned rent-seeking. You also have Amazon, a giant that is not only a giant in online shopping, but also in cloud services. It's attempting to have a federal judge force the Department of Defense give it $10 billion, a $10 billion contract that it lost to a competitor. Not only did Amazon lose the contract on the merits, but giving Amazon the contract would only further cement Amazon's market power and make it harder for new entrants to compete. And finally, several calls to reform the antitrust laws seek to abandon the consumer welfare standard and to instead address non-economic issues like social justice and climate change, or simply punish bigness. It's one thing to support such goals as a matter of personal preference or political popularity. It's entirely another thing to inform families under strained budgets that they will have to choose between the food on their table or the roof over their head because an unelected judge somewhere prefers shopping in local boutiques to the efficiencies that make modern life affordable for the majority of their fellow Americans. All of this is to say that I agree. We do have a competition policy problem, though perhaps not in the same way that many have imagined. What we need now is not a sweeping transformation of our antitrust laws. Rather, this particular moment calls for two things. First, agency leaders with the resources and the will to vigorously enforce the laws we have. And second, congressional action to get the government out of the business of distorting competition. As I've said before, we're at an inflection point in antitrust law and policy, and I'm optimistic that we can find bipartisan consensus on a path forward to improve and strengthen our antitrust enforcement regime. I'm grateful to the chair of our subcommittee, Senator Klobuchar, for opening this incredibly important conversation, for her friendship and for her leadership in this area. And I look forward to making progress in that endeavor and in that direction through today's hearing. Thanks so much.